A case is currently seeking Supreme Court review, which could do away with the federal laws banning people from possessing firearms, and now you have Gavin Newsom and multiple anti-gun organizations who are also asking for the Supreme Court to take up this case. So let's talk about this. But before we jump into this important case, if you think it's time for the Supreme Court to once again strike down some of these gun control laws, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website linked down below. And thank you again to SDI for sponsoring this video. As I mentioned in the intro, in this video we will be discussing a new Second Amendment case which is currently seeking Supreme Court review. The case we will be talking about is called U.S. v. Rahimi, and in this case, the government is actually the one who's asking for Supreme Court review. They have filed a writ of certiorari to the Supreme Court because of a Fifth Circuit decision which was recently issued, and there they found and they ruled that the federal prohibition on gun possession for people subject to domestic violence restraining orders or DVROs is unconstitutional under the Second Amendment. In this decision, the Fifth Circuit three-judge panel analyzed the federal law 18 U.S.C. section 922 G8 under the Supreme Court recent decision in New York State Rifle and Pistol Association versus Bruin. Bruin requires that a government restriction on the right to keep and bear arms must have a historical basis or analog that dates back to 1791. If it does not, then the law must be struck down as unconstitutional. Now, the facts surrounding this case that we're going to be talking about are not great. Mr. Rahimi doesn't seem like a good person. These facts are definitely not the perfect plaintiff, but this is what led to this case eventually making its way up to the Supreme Court. Between December 2020 and January 2021, Mr. Rahimi was involved in 5 shootings in and around the Arlington, Texas area. On December 1st, after selling narcotics to an individual, he fired multiple shots into that individual's residence. The following day, Mr. Rahimi was involved in a car accident as well. He exited his vehicle, shot at the other driver, and then fled the scene. He returned to the scene in a different vehicle and then also shot at the other driver's car. On January 7th, Mr. Rahimi also fired multiple shots into the air after his friend's credit card was declined at a Whataburger restaurant. Officers in the Arlington Police Department identified Mr. Rahimi as the suspect in those shootings and obtained a warrant to search his home. Officers executed that warrant and found a rifle and pistol at his residence, and Mr. Rahimi admitted that he possessed those firearms. He also admitted that he was subject to an agreed civil protection order entered on February 5th, 2020 by a Texas state court after Mr. Rahimi allegedly assaulted his ex-girlfriend. The protective order restrained him from harassing, stalking, or threatening his ex-girlfriend and also their child. The order also expressly prohibited Mr. Rahimi from possessing any firearms. A federal grand jury indicted Mr. Rahimi for possessing a firearm while under a domestic violence restraining order in violation of 18 U.S.C. section 922 G8, that is the federal law. Early in his case, he brought a challenge against that federal law and challenged it as unconstitutional under the Second Amendment. However, he lost that argument since prior Fifth Circuit precedent found under the interest balancing approach that federal law was constitutional. He then appealed that decision up to the Fifth Circuit, who again found that type of argument was foreclosed. But then the Supreme Court issued their New York State Rifle and Pistol Association versus Bruin decision, which reaffirmed the text as informed by relevant history and tradition standard as the proper type of analysis. That Fifth Circuit panel then withdrew their prior opinion and then ruled that under Bruin, their prior precedent was no longer valid and that the federal law prohibiting firearm and ammunition possession by those who are maybe subject to a domestic violence restraining order is in fact a violation of the Second Amendment. In reaching that decision, the Fifth Circuit panel stated, the government fails to demonstrate that section 922 G8's restriction on the Second Amendment right fits within our nation's historical tradition of firearms regulation. The government's proffered analogs falter under one or both of the metrics the Supreme Court articulated in Bruin as the baseline for measuring relevantly similar analogs. Based on that, the Fifth Circuit found that section of the federal gun control laws are in fact unconstitutional and vacated Mr. Rahimi's conviction on possessing a firearm in violation of the law. Now, he still was subject to other charges, but he was challenging this one specific aspect. Obviously, this decision did not sit well with the anti-gun side. In fact, recently during a congressional hearing, multiple House reps brought up this decision and talked about how horrible the Bruin decision was by the Supreme Court and how it's opened the door for more of these types of two-way cases. Well, the government and their representatives did not sit on this loss very long. The government then filed a writ of certiorari up to the Supreme Court. The government actually decided against going to the Fifth Circuit en banc panel review and instead went straight to the Supreme Court. Well, now you also have other people jumping into this case, into this lawsuit to try to get the Supreme Court to grant review. Now you have Gavin Newsom, the anti-gun governor of California, and also anti-gun groups weighing in on this issue, joining the government in petitioning the Supreme Court to grant review. Gavin Newsom recently submitted an amicus brief to the Supreme Court where he also argues that the Fifth Circuit got this analysis wrong and that the Supreme Court must take up this two-way case and to correct this issue. In his brief, Gavin Newsom argues, in New York State Rifle and Pistol Association versus Bruin, as in previous decisions, this court took pains to emphasize that the Second Amendment right is not unlimited. While it protects the right of law-abiding, responsible citizens to use arms for self-defense, it does not disable states from enacting a variety of critical gun control regulations that have existed for decades, including restrictions on gun possession by dangerous individuals. In striking down a federal statute prohibiting firearms possession by those a court has found to pose a credible threat to the physical safety of an intimate partner or child, the Fifth Circuit failed to heed this court's express limits and assurances. The Fifth Circuit's decision threatens the lives of countless Americans. He then goes on to talk about the concurring opinions that were made in the Bruin decision, and he claims that those opinions left in place guardrails that protected government regulations like the prohibitions on persons like this, Mr. Rahimi, from being in possession of firearms. He states that, in the decision below, the Fifth Circuit crashed through those guardrails. While the Fifth Circuit purported to apply this court's new framework in invalidating Section 922G8, it flouted Bruin's instructions. Rather than engage in a meaningful analogical inquiry, the Fifth Circuit rejected a host of relevantly similar historical regulations based on irrelevant and immaterial differences, effectively demanding a historical twin for Section 922G8. Again, here you have Gavin Newsom trying to argue that the Fifth Circuit did not perform the correct type of two-way analysis, that they didn't look at the history correctly before ultimately striking down this federal law. This entire brief by Gavin Newsom and the anti-gun organizations really is very hilarious because Gavin Newsom and his own office are some of the worst offenders when it comes to disregarding the Second Amendment, disregarding the relevant history when it comes to the Second Amendment. So it's very interesting that now he's pointing the finger at someone else, the Fifth Circuit, when really that's what he tends to do and his administration tends to do quite often. But this is still interesting because the favorable decision by the Fifth Circuit and now the government and even Gavin Newsom are jumping in and pushing for the Supreme Court to take up this case. Essentially, every side of this case, the anti-gun side and also the pro-2A side, want the Supreme Court to review this case. They are all arguing for Supreme Court review. Now, we will see if they ultimately decide to take up this case, but even if they don't, it still means that this decision in the Fifth Circuit will be precedent for the Fifth Circuit. So even a denial will ultimately lead to some sort of slight win. It would still be a slight win. That is why ultimately Newsom and these anti-gun groups are jumping in, because they do not want this type of decision to sit as precedent and ultimately affect their jurisdictions as well, maybe influence the Ninth Circuit and some of those other judges to issue a ruling that would ultimately impact maybe something California is doing. So this is a really interesting case, and it's interesting to see even Gavin Newsom sees how important this is and is now petitioning for the Supreme Court to grant review. Now, if anything else develops on this case or other cases, I will let you all know. And if you want to learn more about what's going on in our country in relation to the two-way in our fight, you can watch some of these videos here on the screen. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.